Showing at 3 o'clock by my handy dandy timepiece. So it is my pleasure to introduce Professor Thomas Cotter. Professor Cotter is the Taft Stettinius and Hollister Professor of Law at the University of Minnesota Law School. Professor Cotter's principal research and teaching interests are in the field of domestic and international IP law, antitrust, and law and economics. He's the author of several books, approximately 70 other scholarly works, and over 1,300 posts on his blog, comparativepatentremedies.com. Professor Cotter was appointed an Innovators Network Foundation Intellectual Property Fellow for 2018 to 2021 and was elected to the American Law Institute in 2020. So it's a pleasure to have you, Professor Cotter, and we are all excited to have you present. Just as a heads up, again, I've been harping on this all day. If anybody has any questions for the Q&A or just comments to put in the chat, feel free to do so at any time. We will bring those to Professor Cotter's attention so that he can address them throughout his presentation. Just as a heads up, a little bit of foreshadowing. So after Professor Cotter, we will have another pair of speakers from McCool Smith to close out the symposium for the day. So without further ado, Professor Cotter, it is all yours, and thank you so much for being here.
All right, well, thank you very much. I really appreciate the invitation. So thanks very much to the Texas Intellectual Property Law Journal for inviting me. And thank you very much to the sponsors of today's symposium as well. So my presentation on the economics of injunctions in patent law is based on a couple of talks I gave in Germany in 2019 and a paper that resulted from that was published last year. Oh, let's see, here we go. And so there's a copy of the journal article on which the presentation is based. And if anybody is interested, I will make the slides available after the presentation. And so the paper itself is available on SSRN. So just by way of background, I've been teaching and writing and speaking on the law and economics of intellectual property remedies for longer than I would like to admit, frankly. I've authored, as Roy pointed out, several articles, books, book chapters, and so on this general subject over the years. Among them, a series of articles with an economist, Roger Blair, that ultimately culminated in a book back in 2005, Intellectual Property, Economic and Legal Dimensions of Rights and Remedies. And then I followed that up in 2013 with a book, Comparative Patent Remedies, a Legal and Economic Analysis. I've done a little bit of co-authoring with Professor John Golden of the University of Texas School of Law. We co-authored this chapter on empirical studies of patent remedies that was collected. It was part of an edited volume on the research handbook on the law and economics of intellectual property law that came out a couple of years ago. And then more recently, I co-authored several of the chapters in this edited volume, Patent Remedies and Complex Products Towards a Global Consensus. And also, as Roy pointed out, I've been maintaining a blog, which is sort of a constant update of the Comparative Patent Remedies book. So I try to post something on the Comparative Patent Remedies blog 2 or 3 times a week to the extent I can do that. So some portion of all of this work addresses the law and economics of injunctions in patent cases specifically. And it's fair to say that the question of whether or when courts should award injunctions in patent infringement cases has become more urgent over the past 20 years, roughly, both in the United States and abroad, as we have witnessed over this period of time a proliferation of actions brought by patent assertion entities or involving standard essential patents or non-standard essential patents that are incorporated into complex devices. And when I use that term complex devices, I'm meaning that in the following sense. I'm quoting from other people's use of the term, that a complex device is a product that requires a combination of many components protected by intellectual property rights. And it would be in contrast to a discrete product that might embody one or a small number of patented features. In any event, at present, courts in many countries continue to award the prevailing patent owner a permanent injunction, absent exceptional circumstances. And as I will discuss, that practice was largely followed in the United States prior to eBay and was also largely supported by what I will refer to as first generation law and economics scholarship. But over the past 20 years or so, much of the law and economics literature has taken a more nuanced view that the social benefits and costs of injunctions vary under the circumstances. And so the thesis of the work that I'm going to be presenting over the course of the next hour goes like this, that in general, courts should, number one, grant injunctions when the probability of holdup, patent holdup, as I will define it, is low. And secondly, they should, in general, deny injunctions when the probability of patent holdup is great and the expected harm from valuation error, as I will discuss, is low to moderate. And then for in-between cases or indeterminate cases, courts can mitigate both risks of holdup and risks of valuation error to some degree by granting injunctions subject to stays pending design around. And so where I wind up is actually very similar to conclusions reached by Carl Shapiro a few years ago in his more rigorously mathematical paper, Property Rules versus Liability Rules for Patent Infringement, and that paper can be obtained through that link. So I'll start by noting that the law and economics perspective on injunctions in patent cases is rooted in this distinction sometimes drawn between property rules on the one hand and liability rules on the other. And so this terminology, property rules and liability rules, can be traced back to a law review article published in 1972 in the Harvard Law Review by Guido Calabresi and Douglas Melamed, titled Property Rules, Liability Rules, and Inalienability, One View of the Cathedral. It became one of the most widely cited law review articles of all time. Unlike 99% of law review articles, this one did not fade into obscurity. The authors, Calabresi was a professor at Yale Law School at the time and ultimately was the dean of the Yale Law School and then became a judge on the U.S. Court of Appeals for the Second Circuit. He's now on senior status. Doug Melamed was a law student at the time and went on to a very distinguished career in private practice. And after retiring from that, is now the professor of practice at Stanford Law School. So the two of them collaborated on this article back in 1972 and tried to map out different ways in which the law protects entitlements. And so, first of all, they asserted sometimes the law protects entitlements by means of a property rule, meaning that the entitlement is backed up by a right to injunctive relief. So when this sort of system is in place, if you want to use my entitlement or to take it from me, you have to bargain with me. And if you simply take it without bargaining, then I would be able to obtain an injunction. I would be able to oust you from my property. And so this is the system that we usually, though not inevitably, use to protect real property entitlements and personal property entitlements. Alternatively, though, sometimes the law protects entitlements by means of what Calabresi and Melamed referred to as a liability rule, meaning that the entitlement is backed up by a right to recover damages only. So in a sense, the defendant can choose to breach and pay damages that would be set by a court or some other authority. So under this system, if you want to use my entitlement, you can go ahead and do that, but you will be subject to paying a price. You will have to pay the damages that a court or agency would determine. And so this is usually, though again, not inevitably, how we protect contract rights in the United States. If you and I are parties to a contract and I breach the contract, you would have a right to obtain damages from me. You probably wouldn't have a right to obtain specific performance, a type of injunctive relief, absent very special circumstances. So again, the law makes use of both of these types of systems. And so Calabrese and Melamed, in the course of their article, tried to reason through what the advantages were of property rules, what were the advantages of liability rules, what were the disadvantages of these two things, and when might it be appropriate to select one as opposed to the other. So as far as property rules are concerned, one significant potential advantage is that protecting an entitlement by means of a property rule in theory, should minimize the risk of error and adjudicative costs associated with having a third party determine values. So again, if a court will enter an injunction as opposed to having to determine the damages resulting from some breach of a legal duty, then we don't have to get into the whole issue about how to value what damages the property owner has suffered. We don't have to adjudicate the issues relating to how that value is to be calculated. So at least all other things being equal, a property rule would tend to reduce these potential error costs. The court might value the entitlement incorrectly and the resulting adjudicative costs as well. And somewhat relatedly, property rule also might have the beneficial effect of encouraging the parties to engage in private bargaining, not to bother a court or other agency with their dispute. Again, if you want to use my entitlement, then you ask for it and we bargain it out, but we conduct our bargaining in the shadow of potentially a right on my part to obtain an injunction if you invade my entitlement. Alternatively, though, liability rules have their advantages in certain circumstances as well. So again, as Calabrese and Melamed discussed in their article, liability rules, damages only, may be preferable when there is reason to believe that private bargaining for one reason or another will fail to achieve the optimal outcome. So there may be situations in which the parties simply cannot easily get together and negotiate. Maybe transaction costs are unusually high, or there are other obstacles to bargaining. Maybe the nature of the entitlement is such that it is actually difficult for them to agree on exactly what it is. So there could be a variety of circumstances in which private bargaining may fail or may be extremely costly to undertake. And also, a liability rule entitlement may minimize the risk that the owner of the entitlement would exercise its right in a manner that would, for one reason or another, disserve the public interest, that would actually be harmful to the broader public. So maybe it's useful, at least in some cases, to have this sort of safety valve in place. Now, this distinction between property rules and liability rules is not necessarily as rigid as perhaps I've outlined it here. We certainly have situations in the law where entitlements are protected by liability rules, and we witness parties bargaining around liability rules. That happens, for example, in the copyright sphere, where there are certain circumstances in which the copyright statute allows someone to make use of a copyrighted work for certain purposes upon payment of a compulsory licensing fee. And often what actually happens in the real world is that the parties will negotiate in the shadow of the compulsory license rather than actually resorting to invoking the compulsory license. So you can bargain around liability rules. And also, as Professor Golden has pointed out in some of his work, if you breach an injunction, that is to say, if you disobey an injunction, a court is likely to assess contempt sanctions, which would typically take the form of some sort of monetary penalty. So at least in that sense, in those unusual circumstances, a property rule as well kind of dissolves into a type of liability rule in a sense. So again, the distinctions are not altogether rigid, but in general, property rules have certain advantages as well as disadvantages, and liability rules as well. So as applied to intellectual property rights, what I'm going to refer to as first-generation law and economics scholarship, and this would be in the wake of the Calabresi and Melamed article and going into the 1990s, maybe early 2000s. A lot of people within the law and economics community, a lot of innovation economists were of the view that property rules, by and large, were a good fit for intellectual property rights. Largely for these general reasons that I've already outlined, that property rules have the potential to reduce adjudication and transaction costs. So again, if we have an owner and we have a prospective user and they wish to negotiate, if the owner believes that it would derive more value from the exclusive use of the right rather than licensing it to this would-be user, then that is what the owner will do. And so that actually is economically efficient. That would serve the cause of productive efficiency by ensuring that the entitlement is being exploited by the entity, in this case, the owner, that can make the most productive use of this resource, that can derive the greatest profit or the greatest cost saving from the use of the entitlement. Alternatively, when the prospective user would derive more value from exploiting, say, a patented technology than the owner would from exploiting it itself, then again, the parties have an incentive to enter into some sort of agreement on mutually acceptable terms. But either way, bargaining in the shadow of an injunction would tend to relieve the court of having to determine the terms of a license, if any, that would otherwise follow. And so at the very least, that would tend to conserve on adjudication costs. Moreover, you might think that in the typical case, transaction costs in this sort of situation would not be that unusually high, would not be so high as to impede private bargaining. After all, patents themselves are public documents, and that is one of the advantages of negotiating, say, over a patented technology as opposed to a trade secret. At least with a patent, you have some defined property right to negotiate over. And also, at least in many situations, you would expect that we're only dealing with a small number of parties. So again, transaction costs might well be manageable. You have one owner of the intellectual property right, perhaps one interested user on the other end. So again, transaction costs may not be any impediment to voluntary bargaining. Furthermore, when that's not the case, when transaction costs actually might pose a problem because maybe we have multiple intellectual property rights owners on the one hand and multiple prospective users on the other, if many patents have to be used and combined in order to make a particular product, the firms within the given industry can find their own private solutions to those problems. They can establish institutions to try to reduce transaction costs. And so we do sometimes see this in the real world with the establishment of patent pools, or in the copyright sphere, collective rights organizations like ASCAP and BMI, or standard setting organizations, again, going back to patents. And so firms themselves can come up with these types of solutions, and that's something that a court would not be well poised to craft on its own. And then one final point here is that at least theoretically, maybe property rules are more effective in enabling owners to coordinate follow-up investment in further improvements upon the basic technology or to disseminate useful information to prospective users. At least there's a body of theoretical literature dating back to an article by Professor Edmund Kitch back in the 1960s and subsequent articles by Professor Henry Smith and Scott Keefe that argue that protecting intellectual property rights, in particular patents, by means of a property rule may have these further potential benefits. In addition, and again, going back to the general advantages of property rules. Maybe this is a situation as well where protecting a right by means of a property rule would have the effect of reducing valuation error. And so what do I mean by that in this context? Well, I would say that most economists who look at patent valuation would generally agree with the proposition that the economic value of a patent is the additional profit or cost saving that someone would derive, that a user would derive from using that technology in comparison with the next best available non-infringing alternative. So it's this concept of incremental value. What is the increment of value that flows from using this technology in comparison with the next best available non-infringing alternative? And further, that a royalty, a reasonable royalty or a negotiated royalty should in some sense reflect the ex ante expected economic value so defined. So that's easier said than done, however. Actually valuing intellectual property, in particular patents, is not such an easy thing to do. But you might expect that the parties to a transaction or the prospective parties to a transaction would at the very least have a comparative advantage in comparison with a court or some other agency in trying to estimate what that value is. At least they know what the possible uses are and how they might be deployed, and at least they would have an advantage over a court. So we might expect the parties to be better able to determine the value than a court or some third party would be. And if that is the case, then we might expect courts trying to value intellectual property rights, patent rights in particular, to be susceptible to error. Now, if courts make errors in valuing patents, maybe it doesn't really matter that much in the aggregate, in the long run, if the errors kind of cancel each other out over time. So in one case, maybe the court overestimates the value of the property, and another, maybe it underestimates it. And so at least in the aggregate, maybe there isn't all that much difference. Obviously, it matters to the parties, but systemically, it wouldn't perhaps matter that much. But on the other hand, if errors, judicial errors, would result in systematic undercompensation, then that might be problematic. Again, not only to the parties, but from the larger social perspective as well. Though only if the patent incentive is actually material to the type of technology, the field of technology at issue. And that's a topic I'll come back to a little bit more later in the hour. Also, one might ask, why is there any reason to think that errors would be systemically undercompensatory? I'm not so sure that there are such reasons, although I will note that people do argue that sometimes. For example, in a paper published in 2008, Professor Einar Elhage from Harvard Law School argued that damages would tend to be systemically undercompensatory because infringers would choose to litigate when they would expect patent value to be higher than the average damages award, and to negotiate for a license when they would expect otherwise. I argued in response that that would require considerable foresight on the part of infringers to be able to guess whether the damages they would be awarded if they went, that would be assessed against them if they went to trial, would be over or under compensatory. Moreover, that would be a risky strategy because if you are intentionally, if you are willfully infringing, then you are at least potentially setting yourself up for enhanced damages and attorney's fees, to say nothing of just the high cost of litigation itself. I will note, however, that outside the United States, there may be some reason to be concerned about damages, at least potentially being systemically undercompensatory, particularly in countries in which there is not such widespread discovery as we have in the US, which is pretty much every country doesn't have as much discovery as we have in the US, but some more than others. So I would note, for example, that in China, the prevailing patent owner can request its own lost profit or a reasonable royalty or the disgorgement of the defendant's profit attributable to the infringement. But in well over 90% of litigated patent cases, patent owners in China opt for so-called statutory damages instead. Now, we have statutory damages in the United States for copyright infringement, and a few other countries do that as well. But to my knowledge, only China and Russia at present use statutory damages in patent cases. So in China in particular, the maximum amount of statutory damages awardable for the infringement of a patent is capped at 1 million yuan. That will increase to 5 million yuan as of June 1st of this year. But still, that only comes to about $700,000 in US money. So maybe that would be a situation in which we would have some reason to be concerned that damages might on average be systematically undercompensatory. So that might be an issue some places at some times. I'm not as convinced that that is necessarily true in the US, but there is a debate about that. And then finally, still on the first generation law and economics assessment of injunctive relief, even under that first generation analysis, I think most economists, most law and economics scholars would concede that liability rules nevertheless may be preferable in some discrete circumstances. For example, when the social costs, the lack of access to a particular patented technology are enormous, one might have to make an exception. So in cases involving access to life-saving medicines or other emergency situations where the public or the government really needs to have immediate access to the patented technology, then maybe a liability rule would make more sense than a property rule. But the general situation would be to protect the patent by means of a property rule, right to an injunction. Over the past 20 years or so, however, it's fair to say that a number of economists and law and economics scholars have begun to question much of that preceding wisdom. And the principal concern that has emerged over the past generation is the following: that at least in some circumstances, patent owners would have the ability to use a right to injunctions to extract an ex post royalty that exceeds the ex ante value of the invention, otherwise known as patent holdup. To be a little bit more precise, sometimes, first of all, transaction costs might actually preclude voluntary ex ante bargaining. And so in some situations, just the number of potentially relevant patents might be enormous. If we think of products like smartphones or other complex devices, it can be very difficult even to determine what the universe of potentially relevant patents is in advance of launching a product, much less try to comprehend all of them and figure out exactly what they cover. Are they valid? Are they would they be infringed? And just the demands of certain industries may be that you need to launch a product in a timely fashion, and that might preclude the ability as a practical matter to clear all the relevant patent rights in advance. Moreover, while private solutions like SSOs or collective rights organizations or patent pools may be a terrific solution when they are feasible, we can't necessarily always wait for those solutions to emerge. We might have to act before those types of solutions have come into existence. And so as a result, the threat of being enjoined ex post, that is to say, after having committed to a particular technological path, might result in the implementer, the infringer, agreeing to pay a royalty ex post that exceeds the ex ante value of the technology in comparison with alternatives. You will pay a premium, in other words, not to have to abandon or switch over to another technology after you have already committed to a particular technological path. Or again, to be a little bit more precise about this, the potential premium, the holdup portion of a royalty that you would agree to pay ex post under the threat of an injunction would reflect some portion of your non-salvageable sunk costs. By that, I mean costs that the implementer has sunk to implement a given technology and that would not be deployable or usable if they had to move on to some other technology. So this would simply be a sunk cost that you would never be able to recover, plus the increased cost, if any, of switching to an alternative technology ex post. Maybe the cost of the alternative has increased from what it would have been ex ante. And third, there's the potential that if you had to switch, you would forego whatever benefits, network effects, for example, that would flow from implementing a standardized technology in particular, the access to that particular customer base. So for all of those reasons, there is at least some concern that under some circumstances, a patent owner armed with an injunction could extract ex post this higher royalty, higher than what would be the royalty that an economist would view as the optimal royalty. And if and when that happens, that's bad from the broader social perspective because society winds up paying more than the invention is worth from an economic perspective. Again, the economic value is the ex ante value in comparison with the next best available non-infringing alternative. So this is, at least in some respects, an inefficient use of social resources to be overcompensating the patent owner in comparison with that social value. And also knowing ex ante that you might be vulnerable to being held up ex post might encourage you, the implementer, to undertake unreasonable precautions. It might deter new entry into a particular market. It might render at least some implementers overly cautious about trying to design around or trying to make sure that they reduce the risk of being held up. So again, all of that can be, at least from an economic perspective, an inefficient use of social resources. So maybe that leads to the conclusion that courts should simply deny injunctions in cases in which the risk of patent holdup is great, and maybe those would include standard essential patent cases, complex device cases, patent assertion entity cases, the common thread being here that often the transaction costs of negotiating ex ante might be very high, that once the implementer has chosen to go down a particular technological path, they are in some meaningful sense locked in, or path dependency, meaning that it is hard to turn around and abandon or switch over to something else. And again, that creates at least some risk that the patent owner will act in an opportunistic fashion ex post by demanding a supra-compensatory royalty. That might be disproportionate to, again, the ex ante value of the invention. So, roughly speaking, the concern is that the ex post royalty that an implementer would agree to pay when faced with the threat of an injunction might vastly exceed the ex ante value of the technology. And I should note, by the way, that this is something that, at least in theory, could happen in virtually any country, in any jurisdiction. It might actually be an exacerbated risk in countries that have so-called bifurcated systems. So, for example, in Germany and also in China, for that matter, infringement and validity proceedings are bifurcated. They are separate proceedings. So if the patent owner sues someone for infringement, the case goes to trial court and typically will be adjudicated within about a year, pretty fast. One reason for that is that the defendant typically doesn't get to challenge validity in the court that hears the infringement proceeding. So if a defendant or prospective defendant has reason to doubt that a particular patent is valid, they have to initiate proceedings in a separate forum. And in Germany, actually, this separate forum that hears the invalidity proceedings typically takes about 2 years or sometimes more than that to resolve validity issues. So you have this so-called injunction gap, period of time after which an injunction has issued because the infringement court has found the defendant to be infringing the patent, but we might still have a year or more to find out whether the patent is valid. So during that period of time, the defendant may feel enormous economic pressure simply to agree to a royalty so that it doesn't have to abandon or switch over to a different technology. So maybe this would be the optimal rule, but then again, maybe a bright line rule that you never get an injunction in a standard essential patent case or a patent assertion entity case or a complex device case, maybe that would be overly broad. After all, there might be some cases, perhaps some complex products cases, in which the patent owner's interest really does lie in excluding others from using the patented technology, or maybe it lies in exclusive licensing. And so if a court were to deny an injunction and simply award an ongoing royalty to any and all, that would really mess up the whole exclusive licensing business model, and that might be detrimental. Also, if a court has to award an ongoing royalty in place of an injunction, we still have the error and adjudication costs incident to calculating royalties. Those costs don't just like magically go away. They're still present and maybe are even more substantial. Also, there is at least some risk that maybe we would be encouraging what has come to be called a holdout on the part of implementers. That is to say, where the implementer, the infringer, engages in some sort of strategic delay to try to gain some sort of advantage in negotiation. And that risk might actually be more substantial if the damages award would not be fully compensatory. And I will note here just one thing. In the US, we almost always award prejudgment interest. And in these multi-million-dollar patent cases, that actually can be a lot of money. Prejudgment interest is not always awarded in every other country. It varies a lot from one country to another. Some countries do not award compound interest on damages awards. And so there is at least some potential, at least in some times and some places, that strategic delay may actually be beneficial to the implementer because the courts don't take into account the time value of money, although we tend to do that actually in the United States, at least as far as awarding prejudgment interest is concerned. Also, if courts are too receptive to denying injunctions, then maybe that takes away some of the incentive on the part of private parties to come up with their own institutions for reducing transaction costs. Again, things like patent pools. So maybe we need a more finely grained rule of some sort, although then again, I'm kind of going back and forth here. Maybe some of these concerns about liability rules not being optimal, maybe those are exaggerated. Maybe it isn't really all that difficult for courts to more or less accurately determine the value of the technology at issue. After all, if the court is awarding damages for past infringement, the additional adjudication costs that would be incurred to award an ongoing royalty probably wouldn't be all that substantial, although there might be other terms of a judicially crafted license that could make things a bit more complicated. And again, maybe there really isn't much of a need to worry that damages will be systematically undercompensatory. Again, at least my own view is that it's kind of hard to say that damages in the United States are systematically undercompensatory. CEG events earlier this week in the Western District of Texas. But again, in some countries, maybe damages are systematically undercompensatory. There's also the issue of maybe innovation would not suffer if damages were undercompensatory. And again, I'll come back to that issue in a few minutes. And then as far as holdout is concerned, you could have a rule where a court would award an injunction when it believes the defendant is an unwilling licensee. There does have to be some sort of penalty for failing to negotiate in good faith, in acting in some bad faith fashion, although maybe it wouldn't have to be an injunction either. Maybe it could be enhanced damages or attorney's fees or some other sort of sanction. If there is concern that damages law is not fully compensatory, so again, if there are rules in some parts of the world that you don't get prejudgment interest or you can't get compound interest, maybe it would make more sense to reform those laws rather than to rely on injunctions as some way of trying to make sure that owners are not undercompensated. So it's complicated. What should we do? Well, ideally, I argue in the paper, courts should award injunctions when the social benefits of doing so, in terms of reducing possible harms from valuation error and reducing adjudication costs, outweigh the social costs of injunctions in terms of impeding access or facilitating patent holdup. And courts should deny injunctions when the social costs outweigh the social benefits. That is, if you wanted to try to map this out in some sort of mathematical notation, we could let the probability that holdup will occur if a court enters an injunction in a given case, call that PH. Call CH the resulting social cost if holdup does occur. So the expected cost of holdup would be PH times CH. We could let PV equal the probability of valuation error if a court denies an injunction. Now, maybe the probability of valuation error is like 100%. Courts are always going to deviate from the accurate damages by some amount. So maybe it should be something like the probability that a court will deviate substantially or something like that from the correct amount. And we could call CV the expected social cost if valuation error occurs. Now, maybe that'll be 0 if errors cancel out in the aggregate, or if the patent incentive is not terribly important to a particular field of technology. On the other hand, CV could be quite substantial if, again, there's reason to worry about damages being systematically undercompensatory and that having a negative impact on innovation. In any event, then we've got the expected cost of valuation error is PV times CV, and we could call CA the additional adjudication costs that would be incurred if a court were to award an ongoing royalty rather than an injunction. So ideally, a court would grant an injunction only when the expected social cost of valuation error plus the additional cost of adjudication exceeds the expected social cost of holdup. That is, when ECV plus CA is greater than ECH. Or to restate the inequality, courts should grant injunctions when PV times CV plus CA is greater than PH times CH. But I will concede that is not a very informative rule. That is not a rule you can actually give a court and say, go out and apply this. Note, however, that an automatic injunction rule, in effect, conclusively presumes that the left-hand side of that inequality is always greater than the right-hand side, which may not always be correct. Anyway, but what should we do? So one possibility would be to throw the economics out the window and say we should just decide matters based on non-economic principles, on our intuitions, and those may differ from one person to another. Some people might think that the sanctity of private property is such that courts should always award injunctions. Others might be more concerned about economic liberty or free competition, might be more dubious about the value of injunctive relief. I'm not sure we can really reach any consensus based on these non-economic principles. What I would suggest, what I do suggest in the article, is that what we can do realistically is make some educated guess about the impact of various rules and standards for granting injunctions based on the relative probability, magnitude, direction, and materiality of errors. Do that based on economic theory and empirical evidence, and that may be subject to change over time as the evidence develops. At least in my view, that option makes more sense. Now, I think that we still have to make a couple of simplifying assumptions. So in the paper, I do suggest 2 simplifying assumptions to try to guide the analysis. The first simplifying assumption is this, that it's not, in my view, reasonable to just assume that the probability of valuation error correlates with the resulting harm from valuation error. Sometimes it will, I think, but I don't believe that's always going to be the case. And here's where I get to the materiality of the patent incentive. To the extent we have empirical evidence on how important the patent incentive is in various fields of technology, that empirical evidence over the course of many decades seems to suggest that the patent incentive is more important in fields such as pharmaceuticals, medical devices, and chemicals than in other industries. Now, that's not to say it's not important or never important in other industries, but it does appear, at least based on the evidence we have amassed over the course of several decades, that it's more important in these industries than in others. If that is true, then maybe systemic undercompensation would be more damaging in these fields, pharmaceuticals, medical devices, and chemicals, than perhaps in other industries. There would be more of a concern about undermining the patent incentive. On the other hand, I think it is reasonable to assume that the probability of holdup correlates with the resulting harm from holdup. And I know there's a debate about whether holdup is a real thing or not. I'm in the camp that believes it is, for reasons argued in, among other places, this recent article by Shapiro and Lemley. But in any event, if these 2 simplifying assumptions I'm making are correct, then 3 further principles emerge from the analysis. So here's what they are. So principle number 1 is that courts should grant injunctions when the probability of holdup is low. Now that raises the question, how do you determine when the probability of holdup is high or low? But recall that holdup is more likely to occur when there are high ex ante transaction costs, so it is difficult to engage in ex ante bargaining, and when there are higher than ex ante switching costs, roughly speaking. If the defendant would be substantially worse off ex post if it had to abandon the technology or switch to another one, then it would have been ex ante if it had confronted that choice. So in order to address those issues, we might ask, well, how difficult would it have been to negotiate ex ante? How many patents potentially are embodied in the end product, for example? Are we talking about just a few, or are we talking about potentially thousands? The more patents there are, the greater the risk is that one would be subject to holdup. So there are different ways this may play out, but I argue in the paper that when it is reasonable to conclude that there's a high risk of harm from valuation error and a low risk of harm from holdup, that's kind of an easy case, grant an injunction. So what would be such a case? I think that cases involving pharmaceutical industry probably would fall into this category. Again, if there is any reason to be concerned that damages might, even in theory, be undercompensatory, that might be a particular concern in the pharmaceutical industry, where the patent incentive is extremely important to innovation based on whatever evidence we've already amassed over the decades. And also pharmaceutical companies typically find it in their interest to exclude generic competitors until the generic competition is permitted. That business model would be undermined if courts had to somehow or another calculate lost profits going out into the distant future. So I think there's at least some substantial risk of valuation error, even if the probability of valuation error might be low. And at the same time, it seems like the risk of harm from holdup is pretty low, because typically pharmaceutical product would embody just one or at most a small number of patented features, and there's not much risk that a defendant is going to infringe inadvertently or would be unable to negotiate in advance. So I think that would be the paradigm sort of situation where there's a high risk of harm from valuation error, low risk of harm from holdup. Courts should routinely grant injunctions. Again, except maybe in emergency situations where you need to have public access. That would be the one exception to that. And then another situation that I think is a relatively easy one to address is when there is a low risk of harm from valuation error, but also a low risk of harm from holdup. And so in a case like that, why not grant an injunction? At least that would tend to conserve, even if by a little bit, on adjudication costs. And falling into that category, I think, would be lots of other cases involving so-called discrete products, products that embody only a small number of patented features, whereby the defendant could have negotiated for a license in advance if it wished to do so. So the risk of patent holdup, I think, in these types of cases is relatively low. We may as well, at the very least, conserve on the additional adjudication costs that would follow if we had to grant an ongoing royalty. And, I kind of think these are the cases that probably were the standard cases throughout most of history, where we're probably talking about products that don't embody large numbers of patented features. Maybe that, at least in part, explains why injunctive relief for most of our history and most of the history of the rest of the world had been the standard remedy in patent infringement cases. I will note that this analysis does have the potential drawback that you have to draw some lines. You have to decide if the risk of holdup is high or low, and those terms are not self-defining. Again, we can look to various factors for guidance, but there would be at least some adjudication cost incident to trying to determine whether this is a high holdup case or a low holdup case. Principle number 2 is that courts generally should deny injunctions when the probability of holdup is high and the expected cost of valuation error is low to moderate. That is to say, the valuation error if the injunction is denied. And so examples here, I think, may often include standard essential patent cases, complex device cases, and patent assertion entity cases. At least in many of these cases, again, not necessarily all of them, but in many of them, I think there is a substantial risk of holdup. And again, it may vary from one industry to another, but there may not be that much risk of harm from valuation error. Either damages will not be systematically undercompensatory, or even if they are, maybe it is of less importance to the patent system than it would be if damages were systematically undercompensatory in pharmaceutical cases, medical device cases, chemical cases. And at least in this regard, we do have some empirical evidence. A couple of papers that came out, or the first of these came out a couple of years ago by Mezzanotte and Simcoe, which actually found no evidence that the US eBay decision had negatively impacted US innovation. They tried to measure that by means of various measures, venture capital financing, and so on. And then a follow-up paper by Mezzanotte also concluding that, if anything, eBay has had a positive impact on research and development spending by established firms that apparently view themselves as less vulnerable now to being subject to patent holdup. So at least we do have some empirical evidence that I think is consistent with my principle 2. And then my third principle is that in indeterminate cases, that is to say, when there is a substantial risk of holdup and also, however, a substantial risk of harm from valuation error, then courts should grant injunctions subject to stays. That is to say, you will stay the entry of the injunction for a period of time, maybe 3 months, 6 months, whatever, to enable the defendant to find some way to design around the patented technology, if that is possible. And so this sort of in-between solution at least would tend to mitigate both valuation errors, because the ongoing royalty the court would have to calculate would only be temporary. It wouldn't go on forever. And it would tend to mitigate holdup risk because, again, the defendant is afforded some period of time to design around. US courts do occasionally grant these so-called tailored injunctions, grant sunset royalties. Courts in other countries have the authority to do so under some circumstances, although they actually don't exercise that authority very frequently. So I'll just conclude with a couple of final points about implementation. So in the common law countries, in which I would include the United States, injunctions are discretionary, but this can actually mean different things. So courts in the United States, following the Supreme Court's decision in eBay, apply the 4 factors. And my beef with eBay, or at least the way the courts apply it, is that often they look at the factors more as like elements of a tort or something like that. And I would advise them to consider the 4 factors in an equitable fashion as equitable factors that have to be balanced, and to bring within that some sort of explicitly economic framework. I think that would be a more sensible way to apply the eBay factors than just to apply them in some sort of formalistic fashion. Moreover, I would note that under Federal Circuit precedent, when courts now deny permanent injunctions, they typically will award ongoing royalties using a royalty rate that exceeds the rate that was used for calculating the pre-judgment reasonable royalties. And that seems wrong from an economic standpoint. One reason being that if the point of denying an injunction is that we're worried about the risk that the patent owner will extract a disproportionate royalty ex post, it doesn't make any sense then to award a disproportionate royalty ex post, and kind of defeats the whole purpose of denying the injunction. Moreover, under the Georgia-Pacific framework, the way it is usually articulated, what we are trying to do when we award a reasonable royalty for past behavior is to construct the bargain the parties themselves would have reached ex ante, knowing the patent to be valid and infringed. So if we have accurately calculated the reasonable royalty for the past infringement, we actually don't have any additional information ex post at the time of judgment that should result in a higher royalty rate being awarded on an ongoing basis. So I would hope that maybe someday the courts will see the economic logic of not awarding ongoing royalties at a higher rate. Also, there is at least some possibility in the US that you can kind of do an end run around eBay in some cases by initiating proceedings in the International Trade Commission, where the commission itself only has the authority to award effectively injunctive relief. I mean, that's not technically an injunction, but an exclusion order without taking into account the eBay factors. That might encourage, at least in some cases, a degree of forum shopping. In the other Commonwealth countries, so I'm talking here about the United Kingdom, Canada, Australia, India, countries like that, that have a common law adjudication system. Again, injunctions are discretionary, although at present patent owners still almost always do obtain injunctions in those countries, although it's not an absolute rule. But in those countries, the burden typically rests on the defendant to establish why injunctive relief is not appropriate. In other parts of the world, in the civil law countries, by contrast, the prevailing patent owner at present is still going to be entitled, most of the time, to an injunction, unless the conditions for granting a compulsory license are in place. And that actually turns out to be quite rare in practice. I read yesterday that Russia has awarded a compulsory license in a matter involving a COVID drug, and Germany awarded a compulsory license relating to an AIDS drug about 2 or 3 years ago. But generally speaking, that sort of compulsory licensing is rare. Now, there is this directive within the European Union, the Intellectual Property Rights Enforcement Directive from 2004, that talks about remedies for the infringement of intellectual property rights having to be proportional. And so at least I and others have argued over the last few years that maybe that would provide some means for courts within the European Union, at least, to apply some sort of proportionality analysis and not necessarily award injunctions in every case the patent owner prevails. Alternatively, courts in civil law jurisdictions sometimes can, sometimes do apply other bodies of law, antitrust law, something called the abuse of right doctrine, which could be roughly analogized to our patent misuse doctrine in the United States, maybe contract law, maybe something else, as a basis for denying injunctions, although it's not clear that any of those would readily apply outside the context of standard essential patents. So at least in my paper, I argued that maybe it is time for a new paradigm to emerge, whether that is by making greater use of this proportionality concept or something else. Although I would note that it doesn't look like the German parliament right now is going to make any very substantial changes to German patent law, as we thought they might be poised to do a couple of years ago. So this is still sort of an ongoing evolutionary process around the world. And that is my presentation. Thank you.
Well, thank you, Professor Cotter. We appreciate you coming in. I will give a few seconds for any questions or chats to come in if anybody wants to, but